The Labor Relations Act LRA, 1995 amended 2014. 1. Introduction. The Labor Relations Act LRA, 1995 as amended in 2014 is a South African law that promotes fair employment practices and regulates relationships between employers, employees, trade unions, and employer organizations. It ensures workers' rights, collective bargaining, dispute resolution, and fair labor practices. 2. Purpose of the Labor Relations Act LRA. The LRA aims to promote economic development, peace, and democracy in the workplace. Protect the rights of employees and employers. Provide a framework for collective bargaining and the resolution of labor disputes. Promote employee participation in decision-making. Prevent unfair dismissal and unfair labor practices. 3. Rights of employees and employers. 3.1 Employee rights: join and form a trade union. Participate in union activities. Engage in collective bargaining. Strike under certain conditions. Protection against unfair dismissal and unfair labor practices. 3.2 Employer rights: form and join employer organizations. Engage in collective bargaining. Lock out employees under certain conditions. Expect employees to follow workplace rules and procedures. 4. Key provisions of the LRA. 4.1 Trade unions and employer organizations. Employees have the right to form and join trade unions. Employers can form employer organizations. Trade unions and employer organizations must be registered with the Department of Labor. 4.2 Collective bargaining. Employers and trade unions negotiate wages, working conditions, and other employment matters. Bargaining councils are established to facilitate negotiations. 4.3 Dispute resolution. CCMA and Labor Court. The Commission for Conciliation, Mediation, and Arbitration. CCMA resolves disputes. If unresolved, disputes may be taken to the Labor Court. 4.4 Unfair labor practices and dismissal. Protects employees from unfair treatment by employers. Employees cannot be dismissed without valid reasons and fair procedures. Dismissal is unfair if it is based on discrimination: race, gender, pregnancy, etc. No proper disciplinary process was followed. 4.5 Strikes and lockouts. Employees can strike after following the correct procedures. Employers can lock out workers if negotiations fail. Essential services, e.g., police, health workers cannot strike. 5. Amendments in 2014. The Labor Relations Amendment Act 2014 introduced changes to temporary employment labor brokers limited to 3 months, after which workers become permanent employees. Collective bargaining strengthened trade unions' rights. Unprotected strikes, stricter regulations for fairer employer actions. 6. Impact of the LRA on businesses. Advantages for businesses: creates a fair and stable work environment. Reduces unfair labor practices and disputes. Encourages healthy employer-employee relationships. Provides clear guidelines for hiring, dismissals, and strikes. Disadvantages for businesses: can be time-consuming and expensive to resolve disputes. Compliance with regulations can increase costs. Strikes may disrupt productivity. 7. Conclusion. The Labor Relations Act, LRA, 1995, amended 2014, protects workers' rights while ensuring fair labor practices. It plays a key role in dispute resolution, collective bargaining, and employment relationships in South Africa.